Hello, and thank you for joining our webcast today. My name is AJ Zatola. I'm a partner in our IP transactions practice and also a member of the Venable Ad Law practice group. Today we're here to talk about online contracting. We're going to be giving you a very broad primer, provide you with the ins and outs to assist you with preparing your legal notices and online agreements. If you encounter any technical difficulties, please utilize the Q&A box on the webinar console. We have a very broad and expansive agenda to cram into about an hour. We will try and draw a connection through all of these topics we've identified, starting first with some very basic contract law principles which ground online contracting, moving to some applicable laws, some of which you may be familiar with, others you may not be. We will account for those laws and principles with the basic types of online contracts, namely Clickwrap and BrowseWrap agreements. We will discuss the incorporation of supplemental terms, which is a typical practice of addressing linked or referenced terms. And finally, we will provide, somewhat as an example and discussion, a review of how online notices can both be enforceable and how they are practically applied. In this case, we chose privacy and the GDPR as our arena for discussion.
My name is Stephanie Molyneux, and I'll be kicking us off with the basic contract law principles. So I'll start by providing a background of these principles, and generally valid contracts require offer, acceptance, and also consideration. We'll go through each of these on the next slides. For offer, the offer itself has to have reasonably certain terms, and this is because we would like to have some kind of information to be able to determine breach and appropriate remedies. The offer cannot have just preliminary negotiations, so if parties are merely just discussing what's going on, they cannot actually send out an offer to be able to be accepted by the other party until they have reasonably certain terms. And the UCC is the Uniform Commercial Code, which usually applies to the sale of goods, and the offers under sale of goods transactions usually require less. That's because the Uniform Commercial Code has its own gap fillers, and these gap fillers are used to fill in anything that's missing in a contract, such as price terms or quantity terms. Now, there are some other requirements that are still required under the UCC for the offer of sale of goods, but it is a little bit easier to form this offer under the UCC because of these gap fillers. For acceptance, the person you make an offer to has to accept the contract. And for this, usually we make sure that there are a few things that are complied with. The first one is the mailbox rule, and this just basically helps the offer become accepted because whenever you mail something out in the mail, it's usually deemed accepted upon dispatch. So the recipient does not need to wait for it to be received for it to be effective. We also have something called the mirror image rule, and this just serves to protect the terms of the agreement. And this means that the terms of the offer that are sent out have to be the same as the terms that the offeree is actually accepting. And so it just makes sure that there is a mirror image and that these terms are identical. Under the UCC, which again applies to the sale of goods, there's more flexibility for acceptance, and it depends on the type of transaction. Another important contract law principle is consideration, and this is a bargain for exchange between two parties. And this just means that something needs to be given by both sides. It has to be even. Now, the amount itself does not have to be even, as a mere peppercorn sometimes qualifies for this because the adequacy is not a requirement of the consideration. So as long as something is given from both sides and is received by both sides, then that bargain for exchange between both parties is satisfied and there is consideration. Next, we'll discuss the concept of meeting of the minds. Now, whenever a contract is formed, usually meeting of the minds is always discussed. It's usually, for an enforceable acceptance to occur, there must be evidence that the parties had each, from an objective perspective, engaged in conduct manifesting their mutual assent, and a contract will be formed when the parties have met such a requirement. So this is the key point here is the mutual assent, and to make sure that there is agreement from both parties. And that assent does not expressly require words, but may be inferred from the acts and conduct of the parties. Again, this is from the objective outsider that's looking in, and to make sure that the assent has been achieved by both parties. So it can be done by the acts and conduct. And a meeting of the mind occurs when both parties have notice of the proposed terms prior to manifesting their assent. So again, this goes back to what we were talking about with the mirror image rule. Basically, the terms of the offer have to be the same as the terms of the acceptance to make sure that both sides are equal and that there is a meeting of the minds. So again, we can only have this mutual assent if both parties agree to the same reasonably certain terms. Okay, and the statute of frauds is an important principle in contract law, which deems that certain contracts must be memorialized in a signed writing with sufficient content to evidence the contract. And, sometimes contracts can be formed by that mutual assent that's by the acts and conduct of parties, a handshake, something like that. But under the statute of frauds, there are some contracts that actually have to be in writing and signed in writing. And we'll give you a few examples of these types of contracts. So the first is contracts that cannot be performed within 1 year. Second, agreements for sale or lease of interest in land for a period longer than a year. Third, contracts for the sale of goods involving a purchase price of $500 or more. Generally, this falls under the UCC, the Uniform Commercial Code that we discussed earlier. Fourth, agreements regarding debts of another. Fifth, loans greater than $100,000 that are not for family purposes. So that's all the background information to help frame the rest of the discussion that we will go into for the online enforceability of contracts. But the next part that we would like to discuss are the applicable laws. There are two main ones in this field. The first one is the Electronic Signatures in Global and National Commerce Act, which is commonly referred to as the ESIGN Act. And the second one is the Uniform Electronic Transactions Act, which is UETA. So first, we'll delve into ESIGN. ESIGN is actually a federal law that was passed in 2000, and it renders applicable electronic signatures and contracts legally valid in transactions that touch interstate commerce. So basically, it means that signatures and records cannot be denied legal effect solely because they were conducted online. And this has really facilitated transactions in the past 18 years since it was passed in 2000 because, as you know, many contracts are signed online these days. And so this was the federal law that gave way to that. So under ESIGN, participants of the contracting process should acknowledge or consent to the use of electronic records and signatures as a means to conduct the transaction. So if you think about this, it's just an added requirement that parties consent to doing the transaction online. It's basically just a step before the transaction itself, just making sure that the parties both are aware and consent to doing this transaction online. So this requires that consumers should be able to access the electronic records, and consumers should receive a statement detailing the hardware and software required to access the information electronically. And because this is a federal law, it actually gives way to state law, and we'll discuss the state law next. The state law is the Uniform Electronic Transactions Act, UETA, and this is a model code that was drafted to be able to touch on the state law. And so each state has its own version that it has passed. 47 states have enacted, basically in some form or another, the main Uniform Electronic Transactions Act. And whenever a state adopts it, of course, they have to make some revisions and changes to formulate it based on the other state laws within that state, because sometimes, the will requirements in one state may be different than the requirements in another state. So largely, though, most of the Act is just about the same. So this, again, just like ESIGN, it validates the use of electronic records and electronic signatures in commercial transactions. And the key point here is that it only applies to transactions. This limits its applicability to only those actions between two or more persons engaging in the conduct of business, commercial, or governmental affairs. Although this applies to most transactions, there are usually some common exceptions that are listed within the UETA that is passed in these states. And the two main exceptions are trust and estate law, because usually wills do need to be signed in person to have effect. Trust and estate planning documents also need to be signed in person, sometimes notarized. And the second one are transactions covered by the UCC. Now, there are some transactions under the UCC that are covered under UETA, but it would differ by state. And the third category is just other categories that the state itself enacts. So those two are the main ones that most states have, and then each state also adds its own additional exceptions to it. So UEDA also requires the parties to consent to conduct a transaction electronically. This is the same requirement that we just discussed under ESIGN. ESIGN requires both parties to consent to conducting this transaction online, and UEDA has that same requirement. So if you ask the parties to consent to doing this electronically, you've satisfied both the federal law and the state law. There are two main definitions that are commonly cited under UEDA. The first one is electronic record, which are just records in electronic means. And the second one is electronic signatures, which can be an electronic sound, symbol, or process attached to or logically associated with a record and executed or adopted by a person with the intent to sign the record. So basically, this expands the definitions of records and signatures and allows them to have electronic means. Now, if a law itself in that state requires an electronic record or if it requires a record or it requires a signature, then this electronic record would satisfy that law, and the electronic signature would also satisfy that law. So it really broadens the scope of transactions, and it enables more transactions to be done electronically. So that's it for me, and I'll hand it off to Allison.
Awesome. Hi, everyone. As AJ and Stephanie mentioned, my name is Allison, and I'm an associate in the IP transactions group here at Venable and also a member of the ad law team. And so now that Stephanie has provided us with an overview of contract law, we're going to address issues that clients come to us with frequently concerning online contract formation. And as AJ mentioned, we're going to jump around topics, but the common theme with all of this is that contract law generally applies to online terms and conditions, supplemental terms, and frequently notices. So as we go through, again, there will be a common theme, but we're happy to take follow-up questions, and I think our slides will also be made available to you after the presentation. So one question that we get frequently in our group deals with terms of use or terms of service and end-user license agreements and how they should be presented. So generally, these terms come in one of two forms. The first is a browse wrap agreement. The second is a click wrap agreement. So the first type of agreement, the browse wrap agreement, is when the terms and conditions are provided as a static link on the web page. So generally, they're at the bottom, and the user scrolls through. And one of the keystones of browse wrap agreements is that they employ implicit assent from the end users. So generally, users aren't required to affirmatively accept the terms by clicking a box, which we'll go into. Generally, it assumes that the user, by using the site or software, assents to the terms simply through their use. Usually, the terms of use will include language explicitly stating this, but I'm going to go over recent case law that suggests that not all browse wrap agreements are enforceable. So when clients come to us with questions about browse wrap agreements, we usually turn to the seminal case on the issue, which is Wynn versus Barnes & Noble. So in this case, which was decided by the Ninth Circuit in 2014, the plaintiff, Wynn, ordered 2 touchpads from Barnes & Noble's through the Barnes & Noble's website. So he put in his order, he received confirmation that the order had been received and processed, and then ultimately received an email from Barnes & Noble saying that they couldn't provide him with the touchpads due to a high demand. He brought suit on behalf of himself and other purchasers of the touchpads, and he brought suit initially in the state of California. It was then moved to the district court, and then Barnes & Noble ultimately tried to compel arbitration based on an arbitration agreement or provision that was included in their terms of use. So their terms of use were presented as a browse wrap agreement. There was a hyperlink at the bottom of every single page. There was a hyperlink that was underlined and in green font on every page of the checkout process, and the terms themselves included explicit language that said, by visiting the site, creating an account, or making a purchase on the site that the end user was agreeing to the terms of use. So at issue was whether or not these hyperlinks provided sufficient notice to bind end users to this arbitration language. And ultimately, the court said no. So they held that the terms of use, including this arbitration provision, were not enforceable because the end users didn't have sufficient notice. And in rendering their decision, they cited other cases where browse wrap agreements were found unenforceable because they were presented at the bottom of a page. End users were required to scroll to the bottom of the page, or users were required to sort of click through a process of non-obvious links. They didn't come out and say that browse wrap agreements were uniformly not going to be enforceable. They did say that even in the absence of affirmative consent, the terms could have been made more enforceable through increased notice. But as I mentioned in my previous slide, these hyperlinks were included on every page. They were underlined. They were in green font. So it does weigh against the enforceability of browse wrap agreements. But an interesting thing they did say is that a failure to read the contract does not relieve a party of its obligations under that contract. So I know a lot of times consumers, and I'm guilty of this myself, will have terms and conditions on a site and scroll through them and accept and don't necessarily read them. But just because you didn't read it doesn't mean that it doesn't have effect. And I know we represent a lot of e-commerce retailers, and it's good to know that even if a consumer does not read the terms, they are still enforceable. So we came up with a list of best practices to improve arguments for the enforceability of browse wrap agreements. So these included placing links in a prominent position on every page and making them visible upon loading, making links textually prominent, which could be by using different colors than the rest of the site, including prominent notice saying that use of the site is governed by the terms of use and that the use of the site constitutes acceptance of the terms, naming something, the link something that's easy to understand, like terms of use or terms of service, and highlighting especially important terms like limitations to liability and disclaimers by including them in bold or capital font, just to really increase notice for the end users. That said, when we are advising on choosing between Clickwrap and browse wrap agreements, we generally lean towards Clickwrap agreements. These take the form of a pop-up window or a checkbox that usually scrolls along with the user and requires affirmative consent by checking a box, usually an I agree box, before using the website, software, or services. And absent unconscionability or fraud, these are generally enforced by the courts. And as Stephanie mentioned, this checkbox does constitute an electronic signature. So we also came up with a list of best practices for enforceable Clickwrap agreements. The presentation should be prior to any payment or installation of the software terms. The user should be able to easily read and navigate the terms and should have an opportunity to print and save a copy of the terms. We also recommend offering the user an option to decline that's as prominent as the option to accept. And you want to make sure that these terms are easy to locate for the end user even after they've accepted. So you can't just have them click a checkbox and then the terms and conditions disappear. They need to be able to go back and have the opportunity to review them at a later time if they choose. So when you're deciding between using a Clickwrap or browse wrap agreement, there's a need to weigh the legal certainty of a Clickwrap agreement against the aesthetic or efficiency of a browse wrap agreement. There are some people that don't want to use a Clickwrap because they don't want that box to pop up. They think it ruins the user's experience on their site. We will say that the more that an end user is doing on the site, like interacting with the site, making a purchase, providing information, creating an account, anything of that sort, the more important affirmative assent becomes. A browse-drop agreement might be sufficient for a website geared towards a general audience that doesn't collect sensitive information. So, again, as we were preparing this presentation, we wanted to highlight issues that clients have brought to us in recent weeks. And something that's come up a lot is the enforceability of arbitration agreements in terms of use. And as I mentioned in the Wynn case, the provision at issue was in fact the arbitration provision. And so generally terms of use are considered contracts of adhesion, which means that it's generally between a company on one side and an individual on the other. There's not necessarily equal bargaining power, and the contracts are often presented on a take it or leave it basis. Despite that, they are generally enforceable unless they're unconscionable. So just because you have more bargaining power doesn't mean that you should include terms that are grossly unfair to the customer because a court might not enforce them. But we wanted to highlight another recent case that discusses the enforceability of terms of use or arbitration provisions in terms of use. And this is a 2017 case from the Ninth Circuit called Wisely versus Amazon.Inc. And in this case, the plaintiff brought a putative class action asserting claims under California's competition law and false advertising law. And Amazon moved to dismiss and compel arbitration, again, based on an arbitration agreement and their conditions of use, which are akin to a terms of use, which customers agreed to when clicking through and checking out on Amazon's site. The district court did grant Amazon's motion to compel arbitration, and the plaintiffs ended up appealing the ruling, arguing that the arbitration provision in the COU was unconscionable. Ultimately, the Ninth Circuit ended up siding with the district court. They said that by clicking the corresponding action button on Amazon's checkout and account registration pages, there was an agreement with the hyperlinked COU, again, similar to terms of use. So it kind of goes back to our conversation of choosing Clickwrap versus BrowseWrap. Here, the court said that arbitration provisions in terms of use are not unconscionable, but their decision did turn on the affirmative consent that the end users provided when checking out. All right. So another question we have been getting a lot of recently is about the incorporation of online terms. So I'm sure a lot of you have been receiving or have been using sort of hybrid paper and electronic terms. So you might sign or give a contract that is very short, maybe 2 or 3 pages, but it includes hyperlinks to additional online terms. And so a seemingly short contract might link to dozens or even hundreds of pages of online supplements. We are going to discuss the advantages on both sides for doing this, but we wanted to mention that courts will generally hold that properly incorporated hyperlinked terms are a part of the contract and valid and binding. The question of whether or not these supplemental incorporated terms do form part of the contract hinges on the concept of notice and intent, which Stephanie touched on in her overview of contract law. So we wanted to compare 2 recent cases. The first is Walker versus BuildDirect.com Technologies. And here, the plaintiffs, the Walkers, signed a contract that included language that said all orders are subject to BuildDirect's terms of sale. The signed contract was a paper contract, and it didn't include a web address pointing to any terms outside of the 4 corners of the agreement. These terms of sale were accessible they were readily accessible on BuildDirect's website via a hyperlink that was called Terms of Sale. And the question the court was addressing was whether or not this was sufficient to properly incorporate the terms of sale into the contract. Ultimately, the court said that this was not sufficient. They said that there wasn't enough within the four corners of the contract that would direct the walkers to these terms, and they did not find these supplemental terms to be binding on the walkers in this case. This stands in contrast, though, to another recent case, Bridgman's versus George Hancock, Inc. And here, the defendant included supplemental terms and conditions in their price quotation as a hyperlink. This hyperlink was highlighted in blue, underlined, and bolded. And again, the issue that the court was considering was whether these supplemental and hyperlink terms were properly incorporated into the contract. Here, the court held that they were, and the court noted that there might be a disparity in the amount of notice that is required between parties based on their sophistication. So in the Walker case, the plaintiffs were consumers and unsophisticated parties. In the Bridgman's case, these were sophisticated vendors and, as they called them, experienced buyers and sellers. So the takeaway here is that if you are a retailer and selling to consumers, the court will probably rule more favorably towards the consumers with respect to whether or not terms are incorporated. We're going to get into best practices for making sure they are. But in business-to-business instances, generally supplemental terms will be incorporated and considered part of the contract. So we prepared a checklist of best practices both for drafters and for consumers. I'm going to go over drafters first. So in order to ensure that your supplemental terms that in your contracts are properly incorporated, there are a few things that you can do. You should directly reference the title of the relevant electronic document instead of broadly referring to an entire database, so it's more specific. Clearly direct the reader to the online terms with unambiguous language about their effectiveness on the contract, and include a link, an active link, or a website address. Include a detailed summary of the description of the reference documents to accompany the hyperlink. Ensure the other party receives access to the reference terms, especially when you're providing the hyperlinks. And when you're updating internet terms on your database, you need to make sure that you're updating your contract forms to ensure the accuracy of these hyperlinks and your references and descriptions. Again, you need to have a heightened standard of notice when you're contracting with individual consumers as opposed to corporate entities. So I think we can't stress enough the importance of notice, especially when you're dealing with individual consumers. The more specific and direct you can be, the better. You shouldn't leave any room for confusion. The end user should know that these terms apply. So on the flip side, some of our clients have received very short contracts and believed they were short, and we took a look and it turns out they were actually incredibly long because there were a lot of hyperlinks. And so it's important when you're reviewing a contract to access every single hyperlink on every supplemental document that's formally incorporated into the contract. You need to review and understand these supplemental terms. And another key issue is to consider the order of precedence between the documents. So you might have signed a 2-page agreement that looks very short and has very favorable terms to you. But if they hyperlinked to supplemental terms that were unfavorable to you and included order of precedence language stating that those terms applied over the terms that you signed, you might be out of luck. You might not have received the benefit that you thought you were receiving through this contract. You should also become familiar with the structure and organization of any vendor's online contract database to determine whether or not internet terms apply. And ultimately, you should differentiate between references to electronic documents and references to specific provisions regarding particular business uses, like product specifications. All right. So next, we're going to talk about the enforceability of legal notices. Again, we're switching gears a little bit, but the common theme is about notice. An effective notice is a critical aspect of mutual assent. As we've discussed, effective notice plays an important role in contract law, but it's also critical in other areas of law, such as tort, corporate, and property law. And legal notices appear everywhere. When I was creating this slide, the first thing that came to my mind was FDA labeling rules, all the labels you see on food products. But we thought what would be most relevant and interesting to everyone listening was actually privacy policies. So privacy policies have generally been characterized as legal notices. There is some recent jurisprudence and scholarship suggesting that privacy policies might actually be forms of contracts. Not going to sit here and bore you with the scholarly debate that's going on about that, but I instead want to focus, again, as we have in our previous slides, on consent requirements and privacy policies. I want to caveat this with the fact that the particulars of a privacy policy, including the type of consent required, if at all, depend on the company's industry, jurisdiction, whether or not they advertise or target outside the country, and other business practices. And it's important that each entity makes their own determination about what their privacy policy must address. This is a huge area of law. It is constantly evolving. We have a great privacy team here at Venable that stays informed of all of the changes that are going on, both here in the US and abroad. And they've dedicated their entire practice to this. We could go on for hours, but for right now, we're just going to talk again about the consent requirements. So, as many of you know, a privacy policy is an external-facing statement, and it explains a company's policy towards the collection, use, and sharing of a customer or consumer's data. Privacy law in the U.S. is not unified. It is comprised of various laws, and these laws touch on a variety of different sectors. And as I mentioned, it is constantly evolving, still evolving. Keeps it interesting. And we wanted to focus on the FTC's enforcement of privacy policies under their authority under Section 5 of the FTC Act, and also discuss California state law. California is widely regarded as a state leader in privacy policy legislation. California's Online Privacy Protection Act, also known as CALOPA, was the first state law that required commercial websites and other online service operators to collected data from California consumers to post privacy policies online. So I'm going to talk about the FTC first. So the FTC governs their privacy regime based on the principle of notice and choice. That said, very little has been said about what proper notice and choice actually looks like. The FTC Act does not expressly address consent requirements. It simply requires that consumers give clear and conspicuous notice of their information practices. And a lot of these FTC enforcement actions based on a failure to provide notice are based on the substance and content of the notice itself, not necessarily on the design or presentation of the notice. Again, the substance and content varies widely and is a little bit outside the scope of our presentation, but we are going to talk about different consent requirements. The most recent and relevant case on this issue is the 2015 FTC case that the FTC filed against DirecTV, and they alleged that DirecTV didn't adequately disclose or provide notice of relevant terms in their print, online, mail, and TV advertisements. The terms at issue were bolded, they were all in capital letters, and they were partially underlined. In August of this year, a federal judge determined that these terms, again, bolded in capital letters, partially underlined, stood out visually enough so that DirecTV did in fact provide adequate notice of their terms. But while this is a recent case, there aren't many cases out there on this issue. And the same holds true for California. So under CalOPA, privacy policies must be conspicuously posted. The statute does give some indication and recommendations of best practices, and these including a link titled privacy in capital letters in a type and font and color that calls attention to it. The California Attorney General's Office has also provided similar guidance, but the important part here is that it's non-binding at this point. These are recommendations. CalOPA ultimately says that a privacy policy can be presented as any functional hyperlink displayed in a way that a reasonably prudent user would notice it. So that said, that is how it stands today. But notice and consent requirements for privacy policies might become and are likely to become more stringent under the California Consumer Privacy Act of 2018. So this was passed on June 28th of this year and becomes effective January 1st of 2020. And as drafted now, it will require more stringent consent requirements that guarantee consumers the right to opt out of their data being sold. But at this point, it's still subject to change through amendments prior to its enactment. So I think the main takeaway right now for this is that neither the FTC nor California require end users to provide explicit affirmative consent, like through a Clickwrap agreement, which we talked about earlier, for the collection of personal data. And right now, there's very little regulation regarding how and where privacy policies must be posted and what constitutes assent. Generally, privacy policies are enforceable through a link and implicit assent, akin to the browse wrap requirements we discussed earlier. There are, of course, exceptions that I'm sure you're aware of if they touch your industry. HIPAA requires consent prior to using personal health information, and COPA, or Children's Online Privacy Protection Act, requires verifiable parental consent before using or sharing personal information of children under the age of 13. That said, it seems that there is a trend. We're going to discuss GDPR next, but there seems to be a trend, even in U.S. law, towards moving towards requiring more affirmative consent for end users. We did prepare a list of best practices to enforce privacy policies in the U.S. First and foremost, you should know and comply with relevant industry and jurisdictional requirements regarding the content of your privacy notice and consent requirements that are applicable to you. You should always describe procedures for opt-out policies, if applicable. You should disclose your policy in a prominent location with a clear and conspicuous link. You want to design the link in a font, size, and color that's designed to call attention to itself. Make sure it's included on every single web page. Give it a clear title, as California recommended. Privacy works well in all caps. And be sure to monitor changes in the law and update them often. As I mentioned, the tide is shifting, the law is frequently changing, and consent requirements are likely going to be changing within the next year. And they're changing to reflect likely changing to reflect GDPR. I'm sure a lot of you have been dealing with implementing changes to your privacy practices based on GDPR. It's the legal framework that sets forth the requirements for collecting, processing, and managing personal information of all individuals in the EU. And GDPR applies regardless of where the processing occurs. It went into effect May 25th of this year. And it did actually list consent as one of the 6 lawful bases to process personal data. And they did provide a definition of consent. It's any freely given, specific, informed, and unambiguous indication of the data subject's wishes by which he or she, by a statement or by a clear affirmative action, signifies agreement to the processing of personal data relating to him or her. I highlighted specific for a reason, because it's very important that companies ask consumers for consent for processing data for a specific purpose, and vague or general reasons like improving a user's experience or marketing purposes might not be permissible. I know that definition was a bit convoluted, so we've broken it down into consent requirements that the GDPR recommends. So under GDPR, there is not a prescribed form in which consent must be received, but they do provide recommendations that we've outlined here for you. These include having an affirmative act available to the user, like clicking a box. This goes back to our discussion of Clickwrap agreements. Seeking consent for every different processing purpose. So no blanket consents are allowed. This goes back to what I just mentioned about the definition of specific. Companies should use clear, concise language, but ensure that it's not unnecessarily disruptive to the user's purpose in using the site. You should always avoid ambiguity and make the consent action distinguishable from other actions, like simply using the site, which is sort of akin to a browse wrap agreement. Always avoid pre-checked consent boxes and opt-out formulations that require the user to unclick a box that has been pre-clicked for them. Like the action of clicking the box is very important for consent. And just remember that silence is not consent. So in conclusion, as business is increasingly being conducted online, we think it's really important to understand the law governing online terms, incorporated terms, and legal notices. And while this presentation isn't exhaustive, we hope it can serve as a baseline for you in outlining legal considerations and best practices to increase the enforceability of your online agreements.
There was a lot of ground covered today, and one of the things we encourage with respect to these issues is, although we have attempted to draw a general theme through basic contract law leading up to the consent request process advocated under the GDPR, it is best to take a targeted and focused look at your practices and your contracts. Your practices, policies, et cetera, are going to vary, and it's difficult sometimes to draw generalizations. I would also note that there may be practices that are in play that you have seen on another site, perhaps a competitor's site, that may not actually be enforceable. Understand that in this arena, many of the agreements are between individual consumers and larger companies, and it is infrequent for the consumer to bring suit or file for arbitration. So just because something has been in practice doesn't actually mean it's enforceable. But we've attempted to highlight some of the various themes, draw the connection back to general contract law, in particular the importance of presenting the terms, providing notice, and articulating the action or conduct that constitutes assent. And we feel that those themes will lead into the manner in which privacy practices will evolve, and in particular, how you will need to be seeking consent from your individual consumers. California will likely be taking the lead on this in the coming year. It'll be interesting to see how this evolves. Our suspicion is they will look quite closely at the GDPR. But as you saw from the slides we presented, many of the practices and best practices recommended are similar to basic Clickwrap agreements and to other types of legal notices. And so hopefully from this, you'll be able to come up with your own reasoning that provides a sound basis for presenting your contracts and making sure that they are as enforceable as they can be. We presented our contact information, which we also be sharing as well. This will be concluding our program for today. If you have submitted questions or you have follow-up questions, we'd be happy to try and respond to you directly by email to answer them. Again, there are a lot of different areas in which we can go with this topic and a lot of ground that was covered. So if there are things you didn't quite understand or you require clarity on, please do let us know. I want to provide notice of our next webinar. The final 2018 Ad Law webinar is scheduled for December 13. That will be from 2 to 3 p.m. Eastern. And we'd like to thank you all for joining.